Advocate Siminya.
Good morning, Chair. Good morning, Madam Commissioner. We have set aside today to listen to two applications for cross-examination of certain witnesses. We haven't decided what sequence that will go, and will be subject to the direction by the Chair.
Yes. We'll start with the Seri application.
Thank you, Chairperson. Good morning.
Yes, Mr. Mgomezulu.
Yes. Chair, for the record, I am Osmond Mgomezulu, appearing on behalf of the first and second applicants. First applicant being the Socio-Economic Rights Institute of South Africa, SERI. Second applicant being the Inner City Federation, which we refer to as ICF at times. Chairperson, the applicants have brought an application for the cross-examination of Ms. Helen Margaret Bottes, who has testified before this commission on behalf of the City of Johannesburg. I have already, Chairperson, mentioned the organizations that we represent, but for the record, I will request to outline a brief description of who they are, because that will inform the relief that we seek in our interest in the matter. SERI is a public interest law center and non-governmental organization. It represents approximately 36 inner city buildings in the inner city of Johannesburg, and has been doing so for the past 13 years. It has been involved in a number of socio-economic rights all the way up to the Constitutional Court. The ICF is a self-organization a coalition of tenants of over 40 buildings in the inner city of Johannesburg. The applicants have dutifully been participating in the proceedings of this commission because they have an interest in ensuring that the recommendations made in both Part A and Part B are informed by the lived realities of the people residing in the inner city of Johannesburg. The presentation this morning, Chair, will be structured as follows. I will deal with the brief facts. I will deal with and proceed to deal with the application to cross-examine Ms. Bottes. I will talk about the importance of cross-examination in a commission of inquiry. I will deal briefly with the first and second respondents' grounds of opposition. They have opposed the application. I will address their reasons for opposition and demonstrate, Chairperson, how those fall short of raising a genuine opposition to the application. Then I will conclude with the relief that we seek from this commission, Chairperson. I will then proceed, Your Worship.
Oh,
Yes.
I think this is argument, Advocate Siminya. We don't need interpretation.
No, you would not need it.
Yes. Yes, you may step down. Thank you.
Thank you for that intervention, Chairperson and Commissioner.
Sorry, Mr. Mgomezulu, about that interruption.
Yes, thank you, Chairperson. We feel that it's necessary and useful to provide a factual context for a better appreciation of the issues raised in our application. Say, in February this year, 2024, the City of Johannesburg submitted a sworn statement from Ms. Bottes containing her evidence. She also then appeared before this commission. It was over 3 days, 14, 15, and 16 February, in which she testified, mainly based on the evidence contained in her sworn statement. Raised issues, we outlined those issues, Chairperson, in pages 7 to 8 of the founding affidavit, being the issues that characterized Ms. Borges' evidence. For the record, the issues related to ownership of Usindiso building, the role of the JPC to manage the city of Johannesburg's property portfolio, service delivery agreement between the city and JPC, the lease agreement it had with Usindiso Ministries, the unlawful occupation and inspections. The issues are fully described in the paragraphs in page 7 to 8 of our founding affidavit. Chairperson. And after that testimony, Chairperson, SERIT and the ICF determined that it will be necessary and in the interest of the function of this commission that Ms. Borges be cross-examined. The applicants brought an application on 27 February. The application clearly set out the topics that the applicants wish to cover during cross-examination. For the record, those are the obligations of the JPC as both a municipal entity and as the owner or custodian of the Usindiso building to comply with the following legislation and bylaws of the City of Johannesburg. We mention them in detail, being Part T of SANS 10-400, 10-400. The full reference is contained in the founding affidavit, Chairperson. The Emergency Services Bylaws of 2003, the Problem Properties Bylaws, Waste Management Bylaws, the Electricity Bylaws, 1610 of 1999, the Public Health Bylaws, 179 of 2004, the Water Services Bylaws. Also wish to cover the obligations of JPC in terms of the lease agreement, during the lease agreement and events after the expiry of the lease, the living conditions of the residents of the Usindiso building, conditions that they may have the risk of fire, including the risk of fire. The engagements between and other stakeholders which are mentioned in Ms. Borges' testimony, the extent of those engagements and the outcomes that they yield. The inspections conducted at Usindiso, how the JPC responded to the events after the fire, the categorization of buildings as hijacked buildings and the implications thereof, the zoning. We understand we will elaborate on the issue of zoning because it's one of the grounds of opposition, and generally the requirements for building to meet the health and safety legal framework standards. These are topics that are clearly covered in the application, Chairperson, to say these are the issues that we are interested in that we need to probe further. The application 11 and read with rules 3.7 of the commission. For the record, we state, Your Worship, pardon me for rehashing the
And
the
pardon me
rules.
for calling me your worship.
I profusely apologize, Chairperson. It must be, it must indicate that we appear a lot in the Magistrates Court, but I
Yes.
truly apologize of the work of the Commission to do so. That language is repeated in Regulation 11, Chairperson. A person appearing before the Commission may be cross-examined by a person only if the chairperson permits such cross-examination and that's the relief that we seek, Chairperson, that permission to cross-examine Ms. Borges in terms of this, the rule and the regulation that I have referenced. To bring an application, Chairperson, one has to comply with Rule 11.3, which states that whenever these rules make provision for any person to apply to the Commission or to the Chairperson, the application must be of a substantive application on affidavit with a notice of motion. The affidavit must, amongst others, reflect the relevant facts, the order sought, and the grounds relied upon to seek that order. We submit, Chairperson, that there has been compliance with that rule because the application was brought in terms of that rule and in compliance with that rule. The Commission's work, Chairperson, as contained in the terms of reference, regulations, and the rules, is to inquire into the circumstances, to make findings and recommendations. And the issues raised in Ms. Borges' testimony go a long way in assisting this commission to do its work. But those issues, Chairperson, we submit must be subjected to cross-examination for the reasons that we outline. Say, not only does the evidence of Ms. Borges and the aspects in respect of which the applicant seeks to cross-examine directly relate to the issues in respect of which the applicants have an interest, but it also falls within the scope of this commission's terms of reference. We've already talked about those issues, Chairperson, being the obligations of the JPC as the custodian of the property, compliance with the legislative framework. Moreover, we say that there are witnesses when testifying who had mentioned to this commission that there had been engagements with JPC on the issues that their testimonies covered, being the issuing of notices, non-compliance notices. Mr. Rapulane Monageng mentioned that. There's also a witness such as Mr. The councillor, Mr. Mnyamin, who mentioned that the conditions had been brought, the state of affairs had been brought to the attention of JPC. These are witnesses who, such as Mr. Mnyamin, who came after Ms. Borges. So it's crucial that some of those issues are put to Ms. Borges in order to afford an opportunity to respond, if that is true or not. And if it's true, what was her reaction to those? We've already addressed our compliance with Rule 11.3. I will not repeat. We will then demonstrate, Chairperson, through the submissions I'm about to make, that it is necessary and in the interest of the functions of this commission that Ms. Bottas be cross-examined and that a proper case has been made out for that order that we seek, that we request. I've stated that the provisions that regulate cross-examination before this commission, being Rule 3.7 and Regulation 11, subject to the authorization or the permission of the chairperson. These provisions, chairperson, must be understood as regulating the process of bringing these applications than prohibiting cross-examination or hindering it. The importance of cross-examination in a forum or in a commission of this nature can hardly be overemphasized, because the process, I now touch on the process of cross-examination, chairperson, include to test the accuracy, credibility, the general value of the evidence given in chief, to sift the facts already stated by the witness, to detect and expose discrepancies, to elicit suppressed facts, which will support the case of the cross-examining party. All those purposes apply to this commission, Chairperson. Notwithstanding that it is not a court of law and adopts a more flexible approach to evidence. The commission is not served, Chairperson, by leaving out important evidence, by leaving important evidence unquestioned or untested. The replying affidavit mentions the case of President of South Africa and others versus South African Rugby Football Union and others. At paragraph 61, Chairperson can quickly look at the reference in the reply. Apologies for that.
It's found in page 37.
Okay, thank you, Chairperson. Where we say, as a general rule, it is essential when it is intended to suggest that a witness is not speaking the truth on a particular point, to direct the witness' attention to the fact by question put in cross-examination, showing that the imputation is intended to be made, and to afford the witness an opportunity, while still in the box, of giving any explanation open to the witness and of defending his or her character. If a point in dispute is left unchallenged in cross-examination, the party calling the witness is entitled to assume that the unchallenged witness testimony is accepted as correct. That is the risk that we are seeking to avert, Chairperson, where evidence is not tested or questioned, the result being that it may be accepted in that form. We don't seek to speak for the respondents. They will talk about their grounds of opposition, but for the purposes of my presentation, Your Worship, we've picked up three main points of the opposition. Fact, the one being that the applicants have not and will not call a witness in relation to the matters concerning Part A of the commission. The word used is we want to muddle the issues. The second issue being that the application does not meet the requirements set out in various provisions. And the third one being that the applicants have failed to make out a proper case to cross-examine Ms. Borges, either because she has no knowledge of the issues raised or has already made concessions on those issues, or the issues are not relevant to the Commission's mandate. We say these reasons of opposition lack merit. The evidence given by Ms. Borges applies beyond Part A, and it would be appropriate for the applicants to expect the Commission to, it would not be appropriate to expect the Commission to call her again for cross-examination when we are now dealing with Part B. While the Commissioners, evidence leaders and the parties have not sought to restrain any of the witnesses to evidence required for Part A, the applicant's understanding, Chair, is that the Commissioners will draw their recommendations in both Part A and Part B from the evidence, from all the evidence presented before the Commission. It is for that reason, Your Worship, Chairperson, my apologies, that the applicants have dutifully participated in the proceedings of this commission, because they have an interest, as outlined above, that the recommendations made in Part A and Part B are informed by the lived realities of those residing in the inner city of Johannesburg. There has been a concession in the answering affidavit that it's possible for the applicants could examine a witness by referring to the evidence or version led by others. But the respondents say, but that's not what our application does. That is not correct, because we already say the evidence, we reference the evidence of Mr. Monageng and Mr. Mnyameni. So that attack is misplaced. In any event, Chairperson, the applicants have amply identified the aspects of the evidence of Ms. Borges that necessitated the application. We've read it out, and we've also said it's in the founding affidavit. The issues to be, the topics to be traversed during cross-examination and their relevance, the interest of the applicants in those issues. We say that for that reason, the cross-examination of Ms. Borges is necessary and in the interest of the function of this commission, and that a proper case has been made out. But when one has regard to the opposition of the application, we regard it as, the applicants regard it as meritless for the following main reasons: that it undermines the objectives of this commission to inquire into the circumstances of the Usindiso building tragedy, to make findings as to who must shoulder the liability or responsibility for the state of affairs, death and injuries, and to make recommendations. That function can be exercised if the full evidence is brought to this commission. Its accuracy is tested. So we say, if the cross-examination is not allowed, then the purpose for which the commission was established will be undermined, if not completely defeated. We've talked about the commission not following the rigid rules on matters, as is always the case in litigation in courts. We say the respondents, when I say the respondents, I know, Chairperson, we've cited 3 respondents, but for the sake of convenience, when I say respondents, I'm talking about the City of Johannesburg respondents, Ms. Porters, and the City of Johannesburg, not the 3rd respondent, being the former residents. Residents seek to unreasonably limit the right to cross-examine witnesses before the Commission. Read in context, these rules, the rules 3.7 and Regulation 11, the Commission must be understood to regulate the process and not to hinder the cross-examination of witnesses. Also, the opposition chairperson conflates the rules that are applicable to implicated persons with the rules applicable to an application of this nature, application to cross-examine. We were referred to various rules in the answering affidavit, Chairperson, that we say find no application, and that some of those are found in paginated page 17. That's the answering affidavit of the respondent 17 and 18. They will speak. I don't want to cross Mr. Purwe's line by now, going to his evidence, but those rules, we say they find no relevance because they talk about circumstances where, in the case of an implicated person, where those requirements have to be met. We are not those people, and our application does not even seem to suggest that we are bringing an application because we are an implicated person. There's also an interpretation of Rule 11.3 which does not accord with what is stated in the rule. We have looked in vain.
Well, with regard to Rule 11.3, haven't you made an application and made substantive allegations on which you rely for your application?
That's what we've done. But the one that the respondents are talking about, Chairperson, is one where there are requirements that we should state. It's in paginated page 20, paragraph 6.6. One of the requirements that the applicant for cross-examination must satisfy in his application is stating what he or she wants to admit, or what he or she admits.
Yes, I'm with you.
Yes, all of those. We
Yes.
say we've not seen that. What we've seen is facts,
Yes.
and yes, we've highlighted what Rule 11
They sought to read in Rule 11 what is meant for cross-examination.
possibly once the witness is already on the stand, but in the
Yes.
application itself, there would be, we say, Your Chairperson, that there's no such requirement. And we've said the respondents deliberately seek to obfuscate the applicant's case by invoking various provisions of the rules which are neither relevant nor appropriate for this application. What is of relevance in respect of this application is whether or not the cross-examination of Ms. Portes is necessary and in the interest of the functions of this commission, and whether the applicants have made out a case for that. And we answer affirmatively in respect of both questions, Your Worship. Chairperson, apologies. Ms. Portes is an accounting officer of the JPC, the municipal entity that is the custodian of the building. There are obligations accepted in the answering affidavit that attached to the JPC as the owner, she has considered that there was non-compliance. But the extent of that non-compliance and also the extent of non-compliance must be put to light and questions must be asked in relation to whether or not that state of non-compliance played a role or contributed to the events, to the circumstances of 31st August at Usindiso building. More importantly, this commission has an interest, Chairperson, in hearing her testimony on the steps that have been taken or will be taken by either the city of JPC to investigate with the view of disciplining the responsible individuals or changing policy. If there are people to be disciplined, if it is true that these matters were brought to their attention and perhaps there was dereliction of duty, those are important questions that must be asked, Chairperson. The cross-examination will give the applicants a full opportunity to test the evidence brought forward by her and afford them an opportunity to test her evidence against the version of the other witnesses. If Ms. Borges' evidence, if Ms. Borges is not cross-examined, her evidence will remain unchallenged and might be accepted as correct. It's also a matter of fairness to Ms. Borges, the JPC and the city, that the applicants should put to Ms. Borges any issues in her evidence which the applicants intend to argue should not be accepted by this commission, and allow her an opportunity to respond. Also, the mention in passing the issue of Section 34 of the Constitution, which guarantees everyone the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court or, where appropriate, another independent or impartial tribunal or forum. That will, the ability for the applicants who are participating in these proceedings to test Ms. Borges' evidence will accord with this provision of the Constitution we submit. Drawing towards my conclusion, Chairperson, I've said the other issue to be asked is whether or not a proper case has been made out. Submit, Chairperson, that we have indeed done so. The only thing that we have not done is put in the application the onerous requirements that have been read in by the respondents to Rule 11.3. But purely on the reading of Rule 3, what the applicants were required was to set out the relevant facts, which they have done, the order sought, which they have done, and the grounds upon which that is relied upon. We submit, Chairperson, that the applicants have sufficiently set out the relevant facts, the order sought, and the grounds relied upon for that order sought. Accordingly, a proper case has been made, and it is necessary and will be in the interest of the function of this commission that Ms. Bottas be cross-examined. The applicants pray for an order in terms of the notice of motion, which is an order permitting them to cross-examine Ms. Bottas on a date and time to be arranged by the commission. Those are the applicant's submissions, Chairperson.
Thank you, Mr. Mgomezulu.
Thank you.
Mr. Pure.
Thank you, Commissioner.
It looks like I was not on record. I erroneously pressed switch off. Let me repeat. Good morning, Chair. Good morning, Commissioner Mabena. Madam Commissioner, let me start by saying that we do not intend to regurgitate what is set out in our answering affidavit.
Yes.
Save to assist the commission to make a determination on the application. We will highlight
Yeah.
those areas that are of importance, and that would be our submission without waste of any time.
Yes, before you commence, can we agree that you conflated the procedures applicable to implicated persons to those applicable for cross-examination in your answering affidavit?
Well, we concede that, Commissioner, Chairperson, we do concede that we may have conflated those.
Yes.
Yes. And we say so, Commissioner, and where we coming from with our answer was that this commission is regulated by the provisions as set out in Regulation 3, as we understand. And we appreciate that the applicant before us, or the application brought by the applicant, is for the interested parties. We make no issues and we don't dispute that, Chairperson. We appreciate that they do have an interest. And now that we have considered that, we can actually move to our other.
Yes, I
Yeah.
wanted us to be on the same page with regard to your conflation of issues relating to implicated parties insofar as it relates to cross-examination.
Thank you,
We
Chair.
are on the same page.
We are on the same
Okay.
page, Chair. Chair, if I may then be permitted to deal with the last aspect raised by our learned friend with reference to Rule 11.3. Chair, as we understand the provisions of this rule, it says a substantive application on an affidavit. Equally, we are saying if you bring an application for a determination, you have to substantiate what is it that you want to cross-examine on, what is the purpose, what are you hoping to achieve. Chair, in this inquiry, Helen Bottas testified. She submitted a statement. Her statement was accepted into record. After her evidence in chief, evidence leader questioned Ms. Helen Bottas, and guided by Rule 3.2, and we'll go to that Rule 3.2 of terms of reference. As we understand, Rule 32 of Terms of Reference, Chair, is that evidence leader may put question to a witness whose evidence is presented to the commission by the evidence leader, including question aimed at assisting the commission in assessing the truthfulness of the evidence of a witness. Subject to the chairperson's direction, the evidence leader may ask leading question. We are not talking about that. We're simply saying, evidence leader, when Ms. Botes was before this commission, did put the question. Questions which were intended to establish the truthfulness that will be necessary for the commissioner to assess and to make a determination.
Are you suggesting that the fact that the evidence leader has put questions to Ms. Botes, that writes off the right of cross-examination of the applicant?
We are saying, Commissioner, Chair, where questions have already been dealt with, questions that are intended to assist the commission to get to the truthfulness of what actually transpired. That suffice, Chair. The evidence leader is on assistance, is here to assist the commission to get to the truthfulness, which is the main purpose of this inquiry, to establish exactly what actually transpired on that particular day. Who are the people who were responsible? Who ought to be held responsible for the calamity that took place? If the cross-examination will lead to repetition of what has already been presented before this commission, therefore we submit with respect that it is not necessary that they should be they should be allowed to cross-examine. And we say so in light of what 3.7 is saying. The right to cross-examine, it's not automatic.
Yes. What becomes of the right of a cross-examiner to apply for cross-examination and to be granted such at the discretion of the commission, of the chairperson?
Of course, we
So that becomes discounted once the evidence leader has put certain questions to a witness.
That's not what we're saying, Chair. What we are saying, if the evidence leader has presented evidence that can assist the chair to get to the truthfulness, it is not necessary to recall that witness to repeat one and the same thing. The right to cross-examine is to assist the commission on issues that were left out. And if in the application, in the applicant's application, there is no such, it is not pointed out exactly as to what are those discrepancies that need to be tested. You make a topic, you say on, to make reference, lease agreement, as it was pointed out by the applicant, by Sir. You say, we want to cross-examine the witness on lease agreement. It has been ventilated. There has been some concession which will assist this commission to make a conclusion or to come to a truthfulness of what actually transpired about this transaction of lease agreement. And we are saying you can cross-examine, but don't cross-examine on issues that have already been dealt with.
Yes, Mr. Pura, I have a problem. Help me to understand.
Yes, Chair.
The purpose of cross-examination is to test the accuracy of narration of a witness.
Yes.
How does the questions that have been put by the evidence leader achieve that purpose?
If the evidence leader, Chair, if the evidence leader has probed the truthfulness and the accuracy, the veracity of the evidence that was presented by that witness, suffice to say that, Chair, there is no need. There is no need to cross-examine, because whatever the cross-examiner intend to achieve has already been canvassed by the evidence leader. Evidence leader is here to assist this commission. Evidence leader is here, as we have pointed out in 3.2, that this is what the evidence leader is intended to serve. And a cross-examiner who comes and say, but on the very same point that you have actually asked and interrogated, we also want to cross-examine that witness. We are saying, what purpose will it serve? And we are saying, for that reason, Chair, there is absolutely no need that the witness should be called again. I can't take it to...
I have grave difficulties in understanding your submission, but you may proceed.
Chair, thank you, Chair. Chair, in essence, and that is the nub, that is the
Yes.
that is the nub of our
Yes.
of our argument. And if Chair has got a difficulty in saying that, we say if we may then go further and deal with some of the issues that were raised by
Yes.
by our learned friend.
Yes, you may.
A learned friend made reference to the fact that if Ms. Botes is not called to come and be cross-examined, or Ms. Botes is required to come and testify or be cross-examined so that she can explain what process will be, or what action will be taken against those people who might have actually flouted or did not do their job.
Yes.
We're saying with greatest respect, it's jumping guns, Chair. Whatever is going to happen about the people who, the employees or officials of the department who have not done their job and ensuring that this calamity does not occur. It's a labor dispute that will be dealt with. Ms. Botes
But
cannot...
doesn't it affect the work of this commission? Shouldn't this commission be alive to issues that affect the conduct and the consequences that will be taken as a result of non-compliance of certain instruments?
Chair, if processes have to be taken, the commission is going to make a ruling. The commission is going to make even recommendation as to this are the non-compliance. These are the people who were actually responsible, who failed to carry out their duties as required, and therefore the city should do something about those people. Once that has been set out in the recommendation, the city will then, based on the recommendation of the commission, we are now going to invoke the disciplinary processes as set out in the disciplinary processes of the city. That's what it will happen, Chair. Same applies even if there is a recommendation from the commission that Helen Botes herself, something should be done in that 1, 2, 3, maybe she failed to do X, 1, 2, 3. The city or the executive mayor or whoever who is responsible then say, well, there's a recommendation that comes from the commission that says this, and we are now going to invoke disciplinary processes. That's how we understand that in dealing with people who fail, who derelicted their duty, is going to come from the commission, unless of course we are not covering it in such a way that the commission would want us to deal with it. But that's how we appreciate it, that recommendation of this commission are going to be considered, are going to be implemented. That's what we appreciate on that aspect. Unless a commissioner has got any further question on that aspect before I move.
Yes, you may proceed, Mr. Puri.
Thank you so much, Chair. The other aspect that was raised by a learned friend was that, well, we are, I mean, the respondent are deliberately trying to obfuscate the process. That's not the intention. In an answering affidavit, we give the chairperson an opportunity to look at two versions. And we say, in our interpretation, when we look at your application, it doesn't hold for the following reason. So that the chair and the commission can come to a conclusion after having heard both parties. There's no deliberate intention to obfuscate any process. We appreciate that the commission has to make a determination. So that is why there is an invitation, and we're not taking that invitation to say, well, file your answering affidavit, and then we file it for the sake of ticking the box. We look at the application, say, does this application by the applicant meet what ought to be, what is required for them to cross-examine? Otherwise, we could have said, well, we leave it in the capable hands of the chair. But we then say, Chair, when you consider the application, you should take note of this other aspect. So that is why. So there is no deliberate intention whatsoever on the part of the respondent to obfuscate this process. The other aspect that was raised by a learned friend is that, well, when the inquiry resume for Part B, it will not have the opportunity to call witness and whatever that has evidence of Helen Botes as it was may be accepted as truth. We hold a different view to that, and for the following reason. We say 7.2 of the regulation it deals, the heading is overall evidence at the hearing. Chairperson may, in terms of Section 4 of the Act, summon any person to give oral evidence. How we read this, we're saying, lining it and connecting it to the purpose of the commission. We say there is no preclusion where the commissioner or the chairperson finds that there is certain aspect that need to be clarified, which were not dealt with in the in Part B, that the chairperson can still recall that witness or call a witness to say, can you explain this aspect so that I can make a determination or proper finding on that. And Chair, the other aspect which would be our submission, as I've already stated, that the nub of our case turned on the interpretation and the provision. And we have already made concession to that effect, that we could have conflated issues on those aspects. We are saying we are mindful And we're not saying and downplaying the interest of the applicant. They do have interest in this matter. But as we have said, and to avoid repeating myself, we say where an issue has been canvassed through evidence and through presentation of oral evidence and through questioning, thorough questioning by evidence leader. What is the point of calling that witness again? And let me demonstrate where I'm going to. In case of Mr. Monageng was led by the evidence leader extensively. Subsequent, there was an application. He filed his statement as a witness statement on the 13th of October. 26, when the commission commenced, he was led by evidence leader. Subsequent, there was evidence by Mr. Wynand Engelbrecht. After he came and testified again, questions were put to him on areas, on issues that are covered in the applicant's application. He dealt with all those things. And we say, is that in the interest of this commission to recall that person when all those issues were canvassed?
But we are dealing with Ms. Botes now.
No, I was just making an example of
Yes.
Yes, yeah, we're dealing with Ms. Botes, but I was just saying, that's where we are coming from. And sorry for the overlap, but our case, as it would appear, it is structured along those lines. And we say, in our view, our respectful view, that the applicant has not made out a case to cross-examine Ms. Botes. And those are our submissions.
Yes.
Chair.
Thank you, Mr. Pure.
I just want to quickly confirm.
Oh,
with my-
yes,
with
you
my
may
team.
confer.
Thank you, Chair. We are
Yes,
done.
if I may just canvass one issue.
Yes,
I'm
Chair.
not sure if my recollection serves me well.
Yes.
You had made in your answering affidavit that the fact that Ms. Botes has to be cross-examined on the land use rights
Yes.
has already been covered by Dr. Rabutsecha.
Yes.
There is no need for her to be cross-examined because that evidence has already been covered by another witness.
Yes.
May I have your submission on that?
Thank you, Chair. Where we coming from with that submission is that the question that are put to the witness must be relevant to the testimony of that witness. Dr. Rabutsecha testified about the rezoning, the application of the rezoning, how it applies. As the person who one can say he's got the expertise on the rezoning. That is the relevant witness that the cross-examiner should focus on, to say, you are saying this and we hold a different view. As we appreciate, or as the law apply, this is what it says. So we are saying, do not ask Ms. Helen about that, because there's a witness that could
Yes.
address that.
Yes, but you do concede that Ms. Botes gave evidence in that regard.
Well, we said in so many ways where she has even considered non-compliance, rezoning, and whatnot. That evidence, it's there. And that evidence, it's not controverted by anything. And that's what the chair would actually want to look at, to say, was this evidence controverted? Is there any other thing that could sway me otherwise to make my finding? But if this evidence is uncontroverted, it is what it is, there's a concession to that effect. then that should be it.
Yes. Shouldn't cross-examination be permitted to see if there is consistency with regard to the versions of two witnesses?
Well, equally, Chair, we agree that should be, but the cross-examination should not then prejudice the other person who is going to make comment about the evidence that was presented by another person who is an expert in that.
Yes.
Yes.
But you do concede
We
she
do
did give evidence.
She did give
Yes.
evidence, but the rightful the person who is an expert or who can talk with a with a better appreciation of what is happening is Rabotsega.
Yes.
Yes,
Okay.
that is our submission, Chair.
Thank you, Mr. Pure.
Thank you, Chair.
I
It
think
is
this
quarter
would
past.
be an appropriate time to take a tea adjournment.
As the
We'll
chairperson,
reconvene at 11:30.
as the chairperson pleases.
Advocate Semenya.
Madam Chair, before I sit down, I would request that I make some requests regarding what I think are elements to all of these proceedings that are of a disturbing nature. But let me start in answer to the application say, there is a curious misunderstanding about the inquisitorial nature of commissions. The very reason why cross-examination is not per se a right in cross-examination, in commissions, is precisely because the entire process is inquisitorial by nature. It's not adversarial. If it is adversarial, then you know you have as a matter of right to cross-examine and test the veracity of information placed before you. Now that this is inquisitorial, all of us have a joint responsibility to make sure that we put bare the facts that will enable the commission to make its findings. Those findings would have to be fact-based. The recommendations coming out of the commission would have to be in line with the evidence that has been found and the facts that have been found to be correct. That is the posture that we all must have. Now, what the rule intends to achieve is to say the commission in an inquisitorial position might look at the request for a cross-examination, i.e. determine without more that it does not address matters relevant to it and therefore make its ruling. Alternatively, it is so that if there is cross-examination that is meritorious, it might not, like some indications here, would require cross-examination over 3 days. There, the chairperson would be entitled to say, cross-examination, yes, but only of this duration and only in respect of these matters. That's what the rule is intended to accomplish. I haven't had in opposition anything that is substantively saying why it would be irrelevant for further questions to be put to Ms. Bottas. We would recall, of course, that the evidence of the doctor is in stark contrast to what Ms. Bottas has told us a little earlier. And even for that reason alone, we should be able to say to Ms. Bottas, your version about land use rights, that you're entitled by an instrument of law to migrate it from one to another, is clearly wrong. A witness of sufficient expertise has come and told to the commission that you need to have rezoning applications and you need to have processes and you need to have certificate of compliance, certificate of occupation, and a whole array of instruments that would permit that in-law to happen correctly. Those questions were not put to Ms. Bottas because she denied and said to us, there is an instrument in law that does that. We saw the instrument, it doesn't do that, and we think it would be proper to revisit that matter. Now, we think an application for cross-examination is good. We will depend clearly on your chairperson's directions about its duration. And before I sit down, Madam Chair, I'm making this posture because, and I illustrate it with an innocent party. SERI keeps telling us it has 40 clients who are occupying these buildings. They've never given us one so far. And clearly they must have read the terms of reference. They must know that we are interested in buildings which are occupied by some of its tenants. And clearly this late in the day without them giving us that information is just not helpful. That's not how you posture yourself in relation to an inquisitorial inquiry such as the one we have. And I want to protest that unless they come ashore in the time period that is remaining and tell us what are those buildings and where they are, and so that we can do inspections in loco. I'm going to ask at the end of the commission's hearing that a finding adverse to their post shall be made. I say so as well to MNS. The bulk witnesses that MNS has brought are witnesses that exculpate themselves from any blame whatsoever. So, to the extent that it appears to at least us that these witnesses are coming and seeing MNS as defending them as at an inquiry, it is a completely wrong posture. What MNS should be doing with us is identical. We, as evidence leaders, and MNS and the other attorneys must be coming to assist the commission. That is the comment I want to make before I sit down, Chair.
Thank you, Advocate Siminya. Mr. Pure? Oh, sorry, Mr. Mgomezulu. Any reply?
Thank you, Chairperson. Chair, is a reply to Mr. Purwe or to the?
Yes, any reply that you have.
Yes. Chairperson, I would have addressed the issue of the evidence of Mr. Rabushaka, but that has now been sufficiently covered by
Thank you.
Mr. Semenya. We align with that submission as set out in our replying affidavit.
Thank
There will be
you.
no need to rehash that. Thank you, Chairperson.
Thank you. The ruling in respect of this application is reserved until Monday at 10 o'clock. Next matter on the roll.
Good morning, Madam Chair.
Ms. Subramani?
And Commissioner Mabena. Thank you so much. Madam Chair, the application before the Commission today relates to the application of the Johannesburg Fire Victim Support Group's application for cross-examining various witnesses who were called on either by the evidence leader or the city in the testimonies that have been heard. The application has been opposed, and I will address the argument in respect of the opposition, but I would at the outset, in respect of the applicant as the Johannesburg Fire Victim Support Group. Madam Chair, the applicant wishes to note that throughout the Commission's hearing and in alignment with the evidence leader's discussion about the parties collectively assisting the Commission in ensuring as much information is placed before this Commission to ensure that it is able to do its work and function with proficiency and with as much efficiency as possible. We'd like to note that the applicant has consistently endeavored to ensure that the Commission is assisted as far as possible. We have referenced before this Commission and in correspondence the extensive process of gathering evidence, preparing bundles, and a preparation of an extensive list of witnesses for oral evidence in order to be read into the record for the benefit of this Commission. The purpose of this submission, Madam Chair, is that at all times the applicant has endeavored to not obscure or obstruct the process of this Commission, as the applicants, the victims of the Johannesburg fire at the Usindiso building, have a direct interest. They have a direct impact and live with the aftermath of those effects. We have no interest whatsoever in undue delay. We have, as we speak, and as the Commission is aware, members of the applicant who sit at the Lindela Repatriation Centre awaiting the outcome of this Commission. We would not apply for undue or unnecessary processes with those who hang in the balance in mind. We have thus far allocated resources in Council to endeavour to meet all deadlines and directives issued by the Commission and ensure that the Commission is alive to all external factors via correspondence with the evidence leader or the Secretariat. We understand, and from the very outset with meetings with the evidence leader on day one of this very Commission, that the process of cross-examination was not an automatic right, and therefore we, in alignment with the prescribed rules and regulations applicable to this commission understood that the course of this commission, either through the chairperson's discretion or the evidence leader's guidance, would run at a certain schedule and at a certain pace. That those proceedings should not be arbitrarily interrupted or interrupted prematurely. These submissions are made with reference to the allegations from the first respondent that we had not raised these issues earlier. The understanding of the applicant was that once the schedule of witnesses of both the evidence leader and the city respectively, as well as implicated persons, had been heard, that there would be due time and opportunity given for cross-examination if necessary. And the applicant has considered the witnesses very carefully that it wishes to cross-examine. It does not seek a wholesale bulk re-examination of every witness who has sat before this commission, but seeks to elicit additional evidence from parties who have a direct impact on the victims, who once again form an integral part of Part A of this inquiry. In abiding by these timelines, we again were alerted on the 20th of February by the Secretariat who invited any application as now is the ripe time. We submit that the application is ripe and that it is an appropriate time to align with the Secretariat and the fellow parties to this commission to bring such an application. The sensitivities of timing, we understand that this commission must end its work on Part A at the end of the month. We submit that the time period requested for cross-examination is not lengthy. It is at a maximum of 3.5 days total for all witnesses we seek to cross-examine, where we are absolutely able to concede that if the chairperson would request a truncation of those timelines, that such could be arranged, again, with the sensitivity of the work that the commission must undergo, with set external timeframes and factors that have affected the ongoing process of the commission. The applicants hold the view that cross-examination is necessary to ensure that where disputes of fact have arisen, where mere clarification has not been sufficient to elicit information that is of great interest both to the commission and the applicants as the victims of the Usindiso fire, can be passed, tested, and where needed, bolstered through the process of cross-examination to ensure that the inferences, positive or negative, that are drawn by the commission at the end when its findings are produced by the chair and Commissioner Mabena, rely on information that has been tested, information that is brought to the commission where there can be no mistake about what a party's involvement or the extent of that involvement may have been, insofar as determining the circumstances of the fire, which the purpose of this commission, the function of this commission, have to look at the conditions, the surrounding external factors that impacted. We submit that the witnesses who were sought to be cross-examined are integral in answering the question of conditions. We have heard extensively from the witnesses who were victims of the fire what their living conditions were like. Time and time again, they sat before the commission and before myself or my colleagues explained what their living conditions, the framework of the building, additions to the building may look at. There were references to members of the city having some knowledge. We do not feel it was sufficiently passed, though we, with great respect to the evidence leader who did ask clarification questions, there are perspectives that are informed implicitly through the experiences of the victims that will have to be put, and a version will have to be put with the explicit point of view of the victims, who, I would say, again, are a central component of this aspect of the commission. Put these witnesses in order to elicit additional information so that a finding can be made that is informed from as many perspectives as possible. The respondents have raised an objection to this application for cross-examination. But Madam Chair, I would submit that there has, as my colleague has also said, been a fundamental misreading of the terms of reference and the terms that were cited. Madam Chair, we rely on Rule 3.7 read with Regulation 11 and additionally Rule 11.3. My lady, I'm not going to repeat the full rules, but needless to say that the requirement sought is that the chairperson may permit cross-examination where she deems it necessary and in the best interests of the work of the commission to do so. Regulation 11 has a slight variation which references the interests of the function of the commission. I would submit that cross-examination is vital to ensure that there is no stone left unturned for a commission of inquiry. And I agree with the evidence leader. This is not an adversarial process. The application for cross-examination is not an adversarial one, but one that is deeply and fundamentally inquisitorial to ensure that there is nothing left concealed or falling through the cracks. In addition, we submit that there has been sufficient compliance with Rule 11.3, which requires a substantive application on affidavit with the notice of motion. Madam Chair, I will not unnecessarily go through the papers, but I would submit that in the founding affidavit, it is set out the scope, and the scope is set out not extensively and not broadly, but with specific reference to the areas that for each witness the applicant would wish to re-examine, cross-examine, elicit further necessary information. Madam Chair, I wish to, with reference to the objection, read an extract from the case Buffalo City Metropolitan Municipality and Asla Construction. It is a 2019 case. At paragraph 60, in making a comment on an organ of state raising technical points, the court says the following, and I open with this quote. This court has repeatedly stated that the state or an organ of state is subject to a higher duty to respect the law. As Cameron J. put it in Kurland, additional quote, there is a higher duty on the state to respect the law, to fulfill procedural requirements, and to tread respectfully when dealing with rights. Government is not an indigent or a bewildered litigant, adrift on a sea of litigious uncertainty to whom the courts must extend procedure circumventing lifelines. It is the Constitution's primary agent. It must do right and it must do properly, end quotes. My lady, the court in Buffalo City further goes on to say that a municipality should not adopt technical defenses lightly. The city has based its defenses on technical points that the applicant submits would subvert the process of the fact-finding mission. This fact-finding mission is bound and enshrined by the terms of reference, and once again, aiming to ensure that the victims who bear the brunt of the fire can ensure that they, at the end of this commission, feel that their story has been heard, that their conditions have been fully examined. That cannot be said to be irrelevant. That cannot be said to be redundant. If there is any redundancy, and with respect, Madam Chair, you yourself, where a line of questioning has been deemed irrelevant for the terms of reference and the stated purpose, have intervened. We see no possibility that that intervention would not repeat itself should any line of questioning be irrelevant, repetitious, or unnecessary for the purpose of the work of this commission. The replying affidavit that was filed by the applicants yesterday does pass substantively through the issues of the purpose of cross-examination generally and in the work of the commission. It again relates and is clarifying specifically the rules where we feel that there has been a misunderstanding of the rules that apply to a implicated party versus an implicated party, an interested party rather. My apologies, Madam Chair. The applicant is an interested party. It is deeply vested in these proceedings. It is deeply invested in ensuring that where possible, as much assistance as possible can be rendered. Where the evidence leader may be limited in the scope of clarification questions, cross-examination by the applicant on its own feet would allow for any additional factors to be scrutinized, clarified, and revealed. And clarification is perhaps the wrong word, but I must make note of the fact that, Madam Chair, throughout these proceedings, there has been, I want to say, more than one advocate who has been present. We are a team of volunteers who have acted pro bono for the applicant. This has meant the following. Our resources are constrained. On a particular day, advocates sit and make notes on a watching brief. They are not always empowered to ask clarification questions, as opposed to parties who have been briefed and are resourced and funded to be at the Commission every day. If that process could only happen, and that allocation of resource could only happen because the applicant understood that there would be sufficient time to apply for cross-examination as and when it was deemed appropriate. That clarifications were asked by advocates who would sit here, understanding that that was not the end of the line. A clarification is so distinct from cross-examination. A clarification question deals with the witness on the day of what they've said versus, as the evidence leader has pointed out, a comparison where there are factual inconsistencies or legal inconsistencies as compared to other witnesses. Madam Chair, it is not an abuse of process to approach the Commission on application to acquire an opportunity to cross-examine, understanding that the applicant does not seek a de facto right to broadly cross-examine any party, that we have narrowed the scope, we've set out the scope where the scope of questioning would be directly aligned with issues and factual circumstances raised by the victims who have testified before this Commission. The ad seriatim responses that were also additionally contained in the replying affidavit, Madam Chair, raise a question regarding the authority for the first respondent to depose on behalf of the second to ninth respondents. There is no affidavit on record to show sufficient reasons on affidavit as to why an individual may object to cross-examination. The parties who the applicant seeks to cross-examine are public officials. This Commission is a public forum. The scrutiny that cross-examination seeks is scrutinizing a public official in their function to serve the residents of this metropolitan. Organs of state should welcome an opportunity for transparency. They should welcome an opportunity to give a view where this is not simply a labor issue, as this Commission heard earlier, but this is a human rights issue. It is an issue that looks at the tragedy of 77 deaths, and I must recenter that. 77 deaths, with many more injured and many more walking with the trauma of it. We would be remiss, we would not do justice to both the Commission and the victims who we represent if we do not ventilate as much as possible so that at the end, at the conclusion of Part A, that this Commission, where there is only one bite of the cherry, can sit with as much relevant and important information before it as it can make a proper finding. The applicant is dedicated to ensuring that the best possible evidence sits before this Commission, and that is the heart and core of the application for cross-examination. My lady, I must again assert the particular interest in having insight into liability. While this Commission is tasked with having a fact-finding mission about responsibility, liability, and lesson learning, how can those lessons be learned to ensure that this tragedy is not repeated if we do not look into the state and the organs of state who functionally had some level of awareness, which cross-examination would delve into further to determine how much could have been foreseen by the city before such a tragedy could be experienced, and that from those lessons learned, how can those lessons be properly applied or prescribed by this Commission if we do not fully understand how each player in the large mechanism of the state can change or contribute to the prevention of another tragedy so that more lives do not have to be lost in this beautiful country where we have so many people who are either falling through the cracks or waiting in the balance for the outcome of this Commission. Madam Chair, unless you would like me to pass through the actual application, I think I can stand down for now.
Yes, thank you, Ms.
Thank you.
Subramani. Mr. Pure?
Thank you, Chair. Chair, I do not intend to be long in my reply, in my answering. I think when I was dealing with the first applicant, we actually showed our hands as to where we were going. And, and we considered to the point which the chair engaged us on. And both application, if one has regard to them, they more or less central deal with one and the same thing. And Chair, if I may be permitted for a moment just to give the assurance to this commission as on the concerns that were raised by evidence leader. We take it to heart that we are here to assist this commission to come to a proper finding or to establish exactly what actually transpired on that fateful day. We share the sentiment and are very sensitive to the fact that lives were lost. That much we appreciate, Chair. And from the team, MNS, no intention is harbored to try and frustrate any process of this inquiry. We are here to assist to the best of our ability that we can give the assurance, Chair.
Thank you.
Having said that, Chair, I'll just deal with starting with the last part of my learned friend, that relating to ventilation of issues. We are saying yes, ventilation of issues. That's what we are here for, and to ensure that the commission makes a proper finding. And we are saying, Chair, taking cognizance of the right to cross-examine. And in line with what my learned friend has said, that they are volunteering their service, they are doing the work pro bono. They are working on maybe a string budget. We are saying, in order not to stretch their budget or their resources further, it is for that reason that we've got to be confined, we've got to be direct, we've got to go exactly where this commission intends to go. That is to get to the truth. And where issues have sufficiently been canvassed, and it's a repetition, that is, it does not serve this commission, neither does it serve our colleagues as they say they are working on pro bono. That's what we are saying. We are saying if you are going to make an application to this commission to say we want to call Mr. Rapulani to come and testify, narrow down the issue so that you are able to save the time. In the application, they've said they are likely to spend 1.5 hours on a particular witness. But if the application in their founding affidavit, it is not substantiated that we are going to interrogate this aspect because there was this inaccuracy, therefore, it may prolong the whole process. The witness that they intend to call to spend an hour might be here on days on end and even raise whatever other questions that may lead to any other person to say, we want to re-examine on that. So we are sensitive of that. We are saying, assist the commission. If you appreciate that, you don't have automatic right to cross-examine, but give the commission a substantive application so that as the party that is representing a witness who is likely to be called, should be able to establish that, look, whatever is going to be required of you to come and testify or to be cross-examined on, it is not something that was canvassed. Because just to make, by way of an example, and I'm not going to make too many examples, Madam Chair, I'll just refer to few that I've just highlighted. Insofar as the application to cross-examine Fana Mguni, it is paragraph 22 of the applicant. 22.1, it says, discrepancy between the time of first call received by EMS and alarm call received by ECC. That's what it says. What are those discrepancies? 22.2, comments on first respondents' constitutional obligation to prevent accumulation of waste in a building like Usindiso building as part of his recommendation that the COJ should ensure that all buildings meet all fire safety requirements. Extensively, there is a pick it up person who has testified about that, which is Mr. Mbano, and considered when evidence leader was putting a question that is there anything that you need to do? My recollection and the record will demonstrate that, Chair. He then said, other than what the pick it up is doing in putting the wheel bin or skip, then perhaps there should be some reconsideration of a policy that maybe they could enter the building. Those are the concessions. Why do you still want to cross-examine on that? That point has been thoroughly ventilated. It is for that reason that we say, help the commission to do its work by narrowing down, by pointing exactly what are the issues that you want to canvass. Do not call witnesses just to come here and repeat and regurgitate what they have said. If the record demonstrated that this part was dealt with, do you want to still call that person? That is our submission. And we're saying, again, we are not, and we appreciate the fact, which will be my last part, Chair. We appreciate the fact that the applicant in this matter have been involved with this process throughout. I mean, the applicant are representing the victims of fire, of that incident. That we appreciate, and they need to know the truth. It is exactly for that reason that say we are betting on the same horse, that we want to get to the truth. But in getting to the truth, let's not cloud issues. Let's simplify, sorry, I apologize for that. Let's simplify the work for the commission to get to that point. Chair, those are submissions.
Yes.
Yeah.
Yes.
Unless I need
What
to.
do you say about the point in limine that has been raised by the applicant?
I thought it was a non-issue, Chair, but it appears to be an issue that is persisting. Equally, Chair, I do not know, unless my attorneys have received any, the applicant, for instance, Siri, they have not attached any confirmatory affidavit. Mr. Mnyandu, at all material time, was representing the city. He's got a full mandate of the city. If there is that discrepancy or non-compliance with that, it should not, as it has been argued when it suits the applicant, that the court, this inquiry should not be hard and fast, should not apply hard and fast rule on evidence. On equally, we would make a submission that that should also be relaxed. The commission should relax that provision. Mr. Mnyandu, at all material time, from MNS, has had the mandate of the city to represent all the respondents that are cited in this application. I
Thank
can
you.
only take that far.
Thank you, Mr. Mpure.
Thank you, Chair.
Madam Chair.
Yes, before you reply, I want to give an opportunity to Advocate Semenya and to Mr. Mgomezulu.
That is fine. Thank you, Madam
Oh, not Mr. Mgomezulu.
Chair, we think a proper case has been made for cross-examination, obviously subject to such direction as to time as the chair will give.
Thank you. Mr. Supramani? Ms. Supramani?
Thank you, Madam Chair. Madam Chair, I just have a brief reply on certain aspects of my learned colleague's submissions. Madam Chair, as to the concerns re the resource of the applicant, that was only pointed out to specifically address the issues of why weren't these questions asked in clarification. It was simply to alert Madam Chair and Commissioner Mabena to the fact that our team operated with certain assumptions as to the process, but it does not mean that it is a leeway or a backdoor out of our application. We have a team that is dedicated to the Commission, and cross-examination is not an undue use of the resource where it is for the benefit of both the victims and the Commission. My colleague also speaks to unnecessary repetition. We have made the case that such cross-examination would not be redundant, and that where such redundancies may appear on the day in a certain line of questioning, we trust that the evidence leader or the chairperson herself will halt any time-wasting questions in its tracks. And there is no evidence of behavior from the applicant of wasting the time of this commission. There have been no extensive or extended sequences that would lean to a pattern of behavior that would suggest that the applicant would not honor the commitments and expectations it set for this commission. I think that it is assigning behavior that is not the behavior of the applicant, but is the behavior of other parties to this commission who have been formally reprimanded for delaying the work of this commission. I would not submit that the applicant could be accused of the same. Madam Chair, beyond that, I will submit a proper case has been made. The fact that the applicants are represented by a team of pro bono lawyers is not even sufficient reason to consider that this would be a wasteful use of resources. And that is all I have to say. Thank you, Madam Chair. Thank you, Commissioner
Thank you, Ms.
Mabena.
Supramani. The ruling in respect of this application is reserved until Monday after 10 o'clock. The proceedings are adjourned.